Hi, hello, my dear friends. Welcome back to my channel. ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ಫ್ರೆಂಡ್ಸ್, ಒಂದು ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ನ್ಯೂಸ್. ಇದು ಕೋರ್ಟಿಂದ ಬಂದಿರತಕ್ಕಂಥದ್ದು. ಹೈಕೋರ್ಟ್ ಆಫ್ ಕರ್ನಾಟಕ ಬೆಂಗಳೂರಿಂದ. ಇದು Gpstr 1:1 ಓಕೆ ಫೈನಲ್ ಸೆಲೆಕ್ಷನ್ ಲಿಸ್ಟ್ ಓಕೆ ರಿಲೀಸ್ ಮಾಡೋದ್ರ ಬಗ್ಗೆ ಏನು ಪಿಟಿಷನ್ಸನ್ನು ಹಾಕಿದ್ರು ಅದರ ಬಗ್ಗೆ ಒಂದು ಇನ್ಫಾರ್ಮೇಷನ್ ಲಭ್ಯವಾಗಿದೆ. ಅದು ಏನು ಅನ್ನೋದನ್ನು ನಾವು ನೋಡ್ತಾ ಹೋಗೋಣ. ಇನ್ ದ ಹೈಕೋರ್ಟ್ ಆಫ್ ಕರ್ನಾಟಕ ಅಟ್ ಬ್ಯಾಂಗ್ಳೂರ್. ಓಕೆ, ಇಲ್ಲಿ ಓಕೆ ಅಪೀಲ್ ಓಕೆ ಪಿಟಿಷನ್ ನಂಬರು ಎಲ್ಲನೂ ಕೂಡ ಇಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ. ಬಿಟ್ವೀನ್ ಯಾರ್ಯಾರು ಇದೆ ಅಂತಂದರೆ ನೋಡಿಲ್ಬೋದು. ಅಕ್ಷತಾ ಚೌಗಲ್, ಬೆಳಗಾವಿ ಮತ್ತು ಅದರ್ಸ್ ಪಿಟಿಷನರ್ಸ್, the state of Karnataka and others respondents. ನೋಡ್ಬೋದು, ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಫೀಲ್ಡ್ ಆನ್ ಬಿಹಾಫ್ ಆಫ್ ದ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1 ಸ್ಟೇಟ್ ಅಂಡರ್ ದ ರೂಲ್ 21 of Karnataka High Court writ proceedings rules. The respondents above named respectfully submit as follows. In the above writ petition, the petitioner have caught for quashing the provisional selection list dated 18/11/2022 by respondent number 3, wide annexures A to A10 and for such other reliefs. It is respectfully submitted that the petitioner is not entitled for the relief claimed both on facts and law for the reasons stated here in below. Okay, reasons ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡಿ. There is an alternative stationary remedy available under the law. The petitioner by passing that same field writ petitions which is liable to be rejected according to the section 15 of Administrative Tribunal Act 1985. All the matters pertaining to the recruitment to the post of government services, including the post of graduate primary teacher, shall be decided by the Karnataka State Administrative Tribunal. Undisputedly, the subject matter on the writ petition and also pertaining to recruitment to the post of graduate primary school teacher, and therefore the petitioner out or caught to have approached that Honorable Karnataka State Administrative Tribunal. Therefore, the writ petition is not maintainable. Okay, the petitioners have also sought for a writ in the nature of that mandamus or any other appropriate writ directing respondent number 3 to consider the case of the petitioner number 1 to 8 under category 2A, petitioner number 9 under the category 2B, petitioner number 10 under the category of 3A, and petitioner number 11 under the category 3B in the final selection list, taking note of the caste certificate by Tahsildar respectively, without insisting on the income certificate of the husband of the petitioner, and the same cannot be considered as that entitled or entire selection process will be vitiated in such as event. Therefore, the said prayer is unsustainable. Okay. Next, it is submitted that the respondent authorities have rightly considered the documents furnished by the petitioner in the support of their claim with the regard to income and caste certificate issued by the respective Tahsildars. The norms and the policy of the government is that the income of the spouse shall be taken into the consideration. The term dependent means spouse and children for the married person. No stretch of imagination can be speculate the fact that the spouse after the marriage is dependent on his parents. So therefore, it cannot be termed as that a spouse of dependent on his parent rather than the spouse. So therefore, the askance of the petitioner that their parents' income to be considered and not that of their spouse or unsustainable. So it is not that case of any of the petitioner that they are not dependent on their spouses and they are totally dependent on their parents. So therefore, this is decision based on the prescribed norms and policies of the state is well founded ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಹೇಳಿದ್ದಾರೆ. ಅಂದರೆ ಇದಕ್ಕಿಂತ ಮುಂಚೆ ಏನು ಹೇಳಿದರು, ಓಕೆ, ಮದುವೆಗಿಂತ ಮುಂಚೆ ತಂದೆದು ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿದರು. ಓಕೆ, ಮತ್ತು ಆಫ್ಟರ್ ಮ್ಯಾರೇಜ್ ದೇ ಆರ್ ಎಕ್ಸ್ಪೆಕ್ಟಿಂಗ್ ದಟ್, ಓಕೆ, ಹಸ್ಬೆಂಡ್ಸ್ದು ಬೇಕು ಅಂತಬಿಟ್ಟು ಹೇಳ್ತಿದ್ದಾರೆ. ಬಟ್ ಅಲ್ಲಿ ಆಗಿರ್ತಕ್ಕಂಥದ್ದು ಇವನ್ನ ನಮ್ಮ ಮಿನಿಸ್ಟ್ರು ಕೂಡ ಹೇಳ್ದಂಗೆ, ಒಂದು ವೇಳೆ ನೀವೇನಾದರೂ ಓಕೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಬೇಕಾದ್ರೆ ಅಪ್ಪದೇ ಹಾಕಿದ್ದೀರಾ, ಮತ್ತು ವೆರಿಫಿಕೇಷನ್ ಸಂದರ್ಭದಲ್ಲೂ ಕೂಡ ನೀವೇನಾದರೂ ಅಪ್ಪ ಅವ್ರದ್ದೇ ಕೊಟ್ಟಿದ್ರೆ ಅಲ್ಲಿ ಏನು ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತಾ ಇರಲಿಲ್ಲ. ಬಟ್ ನೀವು ವೇರ್ ವಿ ಆರ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ದಟ್ ಹಸ್ಬೆಂಡ್ಸ್ ಸೊ ದಟ್ ಈಸ್ ನಾಟ್ ಅಕ್ಸೆಪ್ಟಬಲ್ ಅಂತಬಿಟ್ಟು ಅವತ್ತು ಹೇಳಿದರು. ಅದರ ಪ್ರಕಾರನೇ ಇವನ್ ಕೋರ್ಟ್ ಈಸ್ ಆಲ್ಸೋ ದಟ್ ಎಕ್ಸ್ಪ್ಲೈನಿಂಗ್ ಅಬೌಟ್ ಇಟ್. See, it is submitted that the selection policy adopted by the respondent authorities is not arbitrary and it is sustainable in laws as the norms laid down by the DPAR has been followed by the same is herewith produced and marked as annexure R1 reading of the same explicitly states that after carefully consideration and after considering the pros and cons such as policy has been adopted. So however, interestingly, none of the petitioner have challenged in the said policy produced at the next year. So according to that, okay, they have published many things. So these are all, many sheets are there, many reasons they have given about it, that petition. So okay, whoever wanted this, okay, ಯಾರ್ಯಾರಿಗೆಲ್ಲಾದರೂ ಬೇಕಾಗಿದೆ ಇದನ್ನು ನೀವು ಸ್ಕ್ರೀನ್ಶಾಟ್ ತಗೊಂಡು, ಓಕೆ, ಯು ಕ್ಯಾನ್ ರೀಡ್ ಥರೋಲಿ ಆ್ಯಂಡ್ ಗೆಟ್ ಇನ್ಫಾರ್ಮೇಷನ್ ಅಂತ ಹೇಳ್ತಾ ಫ್ರೆಂಡ್ಸ್ ಈ ವಿಡಿಯೋನ ನಾನು ಮುಗಿಸ್ತಾ ಇದ್ದೀನಿ. ಓಕೆ, ಇದೇ ಇವತ್ತಿನ ಈ ವಿಡಿಯೋನ ವಿಶೇಷತೆ ಅಂತ ಹೇಳ್ತಾ ಫ್ರೆಂಡ್ಸ್ ಈ ವಿಡಿಯೋನ ಮುಗಿಸ್ತಾ ಇದ್ದೀನಿ. ಥ್ಯಾಂಕ್ ಯು ಸೋ ಮಚ್ ಆ್ಯಂಡ್ ಥ್ಯಾಂಕ್ ಯು ಫಾರ್ ವಾಚಿಂಗ್.